Thank you. This is Senate Judiciary. It is the day before St. Patrick's Day, which must mean it's March 16th, 2022. And our first topic is the study that we did in the Qualified Immunity Bill, S-254. And after review, we think it should be revised. I don't know how to revise it. So Ben, you've given some thought to this.
Yes, Senator Sears, Ben Overgrowski for Legislative Council. Well, it was this and actually another bill too. But as far as the bill that's before the Senate Judiciary, there are some restrictions for the Office of Legislative Counsel making policy recommendations. And with this bill, if the committee wanted to pick an independent entity, which I think was the goal of the committee in this report, a way to do it could be kind of leave it as an entity independent of the General Assembly would be some potential language. But with this bill in the report here, this seems to be more appropriate in the sense that it's really a legal analysis in a memo before. And if we want to just if the committee wants to make it clear that there wouldn't be any policy recommendations that would come out of this report, that's something that could be done to clarify in addition to the kind of leaving the entity blank, just as long as it's independent of the General Assembly. This was the discussion also as far as S-250 is concerned as well. And I think it's actually more relevant to that bill, but maybe less of a concern here, but it was something nonetheless that I thought was good for the committee to consider.
I'm fine with an entity that's independent of the political process. I don't know how you word it, but an entity, because all we're looking for in this report is factual information about what's happened and what didn't happen. We've gotten the problem that I have with the testimony during our work on qualified immunity has been the diverse opinions of the same opinion. And what happened in this case, what happened in that case. And
Pullman, I am the Executive Director of the Vermont Center for Crime Victim Services.
Jennifer,
and on behalf of the Center.
Jennifer, yeah, thank you. So what I'm just looking for facts. So I don't know that it's something that's why I thought Legislative Counsel was able to do that. We're just looking for an assessment of the various cases that have occurred in Vermont over the last 10 years to better understand what is the state of qualified immunity in Vermont.
And Senator Sears, yeah, and that's something that is completely within the purview of Legislative Counsel. It was just if there were any recommendations that were maybe coming from that.
I think we can make it clear that we don't expect any recommendations. We just expect an analysis of the various decisions by the courts over the past 10 years in cases where qualified immunity has risen as a defense.
Yeah.
Okay.
Yeah.
And I can put in that clarifying language and then circulate a draft. It shouldn't really be a huge addition.
Okay, we could do that before, I can pass over S-254 tomorrow and then have it ready with a new amendment on Friday.
Okay.
I think it may be a little more difficult on 250, but we're not involved in that. That's not our.
I thought on 250, it was joint oversight that was going to do the study and make the recommendations.
It is. We're going to talk about that tomorrow. Because I think if we elect an entity, we probably have to pay them.
Well, yeah, I think that we just left that up to the Justice Oversight Committee about how that would be done, if it could be done with CSG or somebody else, or just the Oversight Committee itself taking testimony. But I don't think in that one that we had alleged counsel doing this.
No, with that one, it was that joint justice shall select an entity in its discretion.
Oh, in its discretion.
I just know that during the discussions, it was brought up that alleged counsel could potentially be an option.
I see what
Right,
you're saying.
and what I'm saying is that a potential way to clarify that language is just to say an entity independent of the General Assembly, which I think would take care of the issue.
And we don't even have to say shall select an entity, we can just say justice oversight. We'll talk about that tomorrow. We'll talk about that.
No, let's talk, that's a really a somewhat different issue. I mean, there's nothing to prevent alleged counsel from, as far as 254 goes, of giving this to a group of students at Vermont Law School, for example. I just want to make sure that's still an option.
And in subsection B, it says that alleged counsel, shall have the administrative, technical, and legal assistance of the Attorney General, the Defender General, and the Center for Justice Reform at BLS, and other stakeholders interested in assisting.
Okay, so I think as long as you make it clear that we're looking only for a report, not a study, and we're not looking for policy recommendations, we're merely looking to understand what really is the state of the laws in Vermont.
Yeah.
Well, I should say case law, because there are no laws, it's all case law. All right, is everybody okay with that? I mean, even those, I realize 2 members of the committee voted against the bill, but I really don't want to see this part of it become a huge issue on the floor.
I'm fine with it.
Sounds good to me.
And Senator Sears, just as a clarification for me, so this would a floor amendment offered by you, or?
Yeah, I think in this case, it'd probably just be me offering a floor amendment, since we don't have unanimity. But if Senator White and Baruth want to join me, that's fine.
It's really just a technical change.
Yeah, Senator Baruth has put a thumbs up to join me on that one. And Senator White, it's up to you.
Oh, I'm fine, yeah.
Okay, Sears, Baruth, and White.
That was a very Minnesota, oh, I'm fine.
Yeah.
Did that?
What?
The very Minnesota, I'm fine.
Oh yeah, that's a Scandinavian thing, I'm okay. Oh yeah.
Oh yeah.
I'm fine being on there.
I'll add you as well.
Ben, thank you for raising the issue, and I think that will clarify it.
Okay.
And obviously, it has to go through the House and the governor, so we'll see what happens.
Okay. I'll make sure that that's drafted up, and I'll circulate it to you, Dick, so that you can take a look.
Okay.
No, all municipal.
So we're gonna switch to S-250. Somebody is talking and I'm trying to talk.
It's me, I'm sorry.
Which is all right. So we're gonna switch now to H-523, which is the bill dealing with sealing of criminal records. And we're gonna start.
That's what we were talking about here.
Oh,
Alice
okay.
and I'm sorry. This is so what I gave Alice was, there was the section that dealt with expungement of municipal records except those in chapter 1117 or 117. And I just showed Alice what's in 117, which is all planning kinds of records and violations. So
Okay,
that's what I was showing Alice, that they would not be expungible, anything in there.
okay, but this is H534. An act relating to sealing of criminal records. And our first witness is Madrid O'Reilly, the staff attorney of Vermont Legal Aid. Nice to see you again. Happy New Year.
Hi
I don't
there.
think we've seen you all, but this year you've been
Yeah.
focused.
Yeah, you have not. Thanks so much for inviting me to testify. I am Mairead O'Reilly from Vermont Legal Aid. I just first want to commend your committee on the work you've done on record clearance over the years. Legal Aid has consistently come back to this committee primarily to advocate for an expansion of the list of eligible crimes to include felony property offenses. That's still a priority, and we're excited that it's included in H534. But your committee, throughout the time that we've been pushing for that, your committee has worked through and passed reform that has had a profoundly significant impact on Vermonters. Specifically, the legislation related to a more automated process to expunge and seal dismiss charges, an expansion of the juvenile sealing law, and the ability for low-income Vermonters who are unable to pay their surcharges for those surcharges to be waived. And I say that because in the last week alone, I've been in contact with two former clients, two women in their 30s, both mothers, who, when we worked together in 2019 and 2020, were not able to seal their felony drug cases because they were over the age of 21. They were in their early 20s still, 22 and 23. But one young woman contacted me earlier this week about, a ministerial thing. She wanted to know where her expungement orders were sent years ago. And so we talked about that a little bit and where they probably went and how she could gain access to them. And that gave me an opportunity to look at her record again and let her know that her felony drug offense from when she was 23 was eligible to seal. And she started immediately sobbing and said that she had completely given up hope that she would ever be able to find good housing or actually get into a career. So, she thanked me and thanked me and thanked me. And I felt, of course, gratified, but realized that I really need to pass on that gratitude to you all for the work that you've done, because, I get to help her petition the court for sealing, but without the work that you've done in this committee, that wouldn't be possible. So, I just want to commend you on the work you've done, pulling Vermonters from economic marginalization back into the economy. So back
Thank
to
you.
the bill at hand, which is H534. Legal Aid supports this bill fully. We would support it if it were passed today as written. But we also understand that there's likely going to be some significant deliberation on the definition of sealing. From our perspective, what we appreciate most about this bill and what we hope will remain during deliberations in this sort of phase is that Vermonters would still be able to clear more types of offenses from their records, and that the wait times remain tailored to the literature on recidivism and the utility of old criminal records. The impacts from my estimation and some number crunching that I did with Robin Joy, it looks very significant. It looks like tens of thousands of Vermonters would have records that were eligible to be sealed if this were to pass. And from the legal aid client population perspective, clearing criminal records from the public view the moment there is no longer a legitimate public safety reason to maintain that public facing record is crucial. It really For most people, for those who don't have a lot of social capital or connections, it really isn't until their record is cleared that they can begin their process of full reintegration in earnest. So we would, we support and hope that those two provisions would remain in the bill as deliberations continue. And we would also continue to support the restricted access to sealed records as is outlined in version 5.2 of the bill. We admit that this is a compromise. It was an attempt.
To hear you. It's hard to hear you.
It's hard to hear me?
Yes.
Okay. I will try to speak up.
Thank you.
We would continue to support the restricted access to sealed records as outlined in version 5.2, but do want to admit that it's a compromise. It was an attempt to move towards the expansion of the sealing remedy with limited wait times while moving away from that unfettered law enforcement access to sealed records. This, we've maintained is overly broad and it's prejudicial to people who've had some prior criminal legal contact. We agree with the Attorney General's office that it actually could be information that confuses the issue, particularly at a roadside stop, rather than necessarily helping it. And
Yeah, I think there's somebody who's not muted that's where it's coming from. So
I think it might be Jay.
Thank you, Jay.
I apologize, Senator Sears and committee members. I'm seeing that that's me.
no problem. No problem.
I'm
Understood.
sorry, Marita. I apologize.
that's okay.
No problem.
So what we've maintained over the years is that access at roadside is something that we think Vermont needs to move away from. And what you see in H534 is the result of what stakeholders have attempted to determine instances where the access would be a bit more reasonable and a bit more sort of premised on public safety. So our position is that H534 strikes a balance that on the whole is better than our current system because of what it will afford Vermonters, which is broader relief. But I totally agree with the Defender General that perhaps having David Diamora in to talk about whether, certain actors like DOC or the courts and prosecutors, whether there's any merit to them retaining access after the wait times, the 3 and 7 years. And the only potential,
You just went away.
what's that?
We
The
can't hear
only-
you.
You
You
can't.
started the only potential.
Yeah, the only potential amendment suggestion I would have aligns with a comment made by Senator Baruth yesterday about the unauthorized disclosure provision. He mentioned that perhaps it should be expanded to unauthorized use. And I made a similar observation in House Judiciary this year and suggested a sort of more protective provision. If this committee's work ends up resulting in a system where there is some access to sealed records, I do think, something to say any use of a sealed record outside of what's permitted in the bill is unauthorized use and is prohibited. Because as he observed, right now, it's really just for unauthorized disclosures. And there are other ways in which people could be harmed just by, others accessing their record, even if they don't disclose it outside of, their office. And I just want to also respond briefly to something that was proposed by the Department of State's attorneys and sheriffs. They flagged this over in House Judiciary and we responded, and I'll respond here. They argue that, or they propose that multi-count, there should be an amendment to how our systems deal with multi-count cases. They requested that, when a single case has multiple charges, any charges that get dismissed as part of a plea agreement should not be eligible for sealing until all charges are eligible. And he talks about how the redactions of parts of the case can be really impossible. And then he also talked about an error that was made by one court. So I just want to remind the committee that this, there's been a lot of work on this exact topic in 13 VSA 7606 and 7607, which, if you remember, years ago, the judiciary struggled with redacting affidavits. And so the law was amended to ensure that really what happens in a multi-count case when one charge gets expunged is that the remaining offenses, there's no redaction required, and the court simply has to remove the expunged or sealed offense from any public database, but the case file remains publicly accessible. And it's not until all charges get expunged that the case file has to be destroyed. But this still has a very important impact for our clients, because they primarily, what decision makers are looking at is that the sort of the criminal record that's being reported by agencies like VCIC. Sorry about the barking. So it's, they're able to say, their record is really winnowed down to the cases that have not been expunged or sealed. And I don't think that we should, have to retain those records. I'm sorry, simply because of new puppy, and he's not happy right now. Simply because of these administrative concerns, which I think have already been addressed. So that's all I have to add at this time. I'm happy to answer any questions.
Well, I think if I might be oversimplifying the issues, but this bill has to do with which crimes are eligible for sealing and what is the length of time that each type of crime might carry in terms of how long after everything has been all the judgments and time has been satisfied, how long before the person is eligible to have it sealed. And because there's no automatic sealing, it still is up to the state's attorney to determine that. And then the question is, who has access to the sealed records? And yesterday I was reading the laws regarding the sealing of juvenile records. And that's been on the books for, at least 40 to 50 years. It's been updated, but I was looking at that, and then also looking at deferred sentences and when they're sealed or expunged. So I think there's a lot of experience with this. I do remember the testimony in Winooski about 2 years ago in February, just before we shut down during the pandemic, was on S7, and some of your clients at that meeting in Winooski, it was very, very heartfelt and very interesting. And it seemed like people waited a longer time than they had to get their records expunged. And many of the people, as you said, it's more than 20 years.
Exactly.
Could there be a two-tier system of, say, it's a misdemeanor, and after 3 years, certain records are sealed. You would have your follow what is in S524 from the 530 from the House, and then after another 3 or 10 years, 6 years or something like that, then everything is completely sealed. Is that a possibility? Would that, so that I think what I'm hearing from state is law enforcement. I haven't heard from law enforcement yet, but I think they're concerned with roadside access. So you might have some access, but when I, you know, MT from Bennington now lives in Hoosick,
Yes.
New York. She was there in February, and her case is so old that I don't know that there's any. She didn't even commit the crime that she pled guilty to. She was protecting a relative. So,
Right.
you know, you go back to that, and I don't know if they need that if she stopped on the highway.
Yeah, yeah. I mean, I think that what H534 attempted to do is what you're articulating now is sort of a two-tiered, but I mean, without seeing language, I can just say that I think we agree in concept that, you know, as soon as we can seal it from the public so that folks can apply to housing and apply to jobs, like that's of primary importance to legal aid clients. We would want to make sure that there's, you know, if law enforcement is going to gain access, it's limited. So, you know, we attempted to identify actors we thought had a legitimate purpose. But I think someone like David Diamora could help us figure out whether there are public safety reasons why, you know, a 3-year-old misdemeanor, you know, should continue to be accessed by, you know, line law enforcement out patrolling, or whether that's, you know, just really not supported by the literature. But I completely agree that, you know, some sort of a two-tiered, like it has to be sealed from the public as soon as it can be. And then, you know, after a certain period when there's not really any public safety reason to maintain it, it gets sealed from the system actors.
Yep. Okay. Well, it's just a suggestion as a way to go about it. And thinking of that particular case, I don't have any questions for you.
Yeah.
But
And
it's nice to see you.
just to respond to the MT client from Bennington, I do agree that it would be, I think that's a really creative and good solution, that there are some low-hanging fruit kinds of cases that no one's going to care about and no one's going to dispute. So maybe breaking it off into, you know, like felony offenses that are older than X amount of years, you know,
right.
They're cleared, you know, fully and immediately, or like fully the first time they're cleared.
Yeah. If it's been
Yeah, it's been long enough. That's right.
Go ahead. I was just saying that I'm finished, and go ahead. Yes,
Well,
sir.
I just have a quick question for Ray Reed. This is Joe Benning. You probably can't see me very well on the screen.
Hi, Senator Benning.
I understand you're changing jobs.
I am changing jobs, and I was going.
You should know where you're going.
Yes. So I will be leaving legal aid, and my very competent, wonderful colleague, Emily Kenyon, will be taking over on this bill. And I am going to join the public defenders in St. Albans.
Welcome to the club.
So this is the last time you'll see me, which is
wow.
probably why I had to go down memory lane and just revisit all the accomplishments of this committee, because yeah, it's significant.
Well, thank you for everything and all that you did for various individuals during your career, particularly in expungement. And I know that we worked on several together, and we do appreciate it. Maybe we'll hear from you as the public defender in Franklin County. I don't know. They've got a lot of problems up there, so they need you.
Yeah. Thank you.
Happy trials.
Thank you. I appreciate it.
Yeah. Well, good luck.
Thanks.
Yeah, good luck.
All right. Our next witness, and good luck with the puppy, Midri. That's an exciting
That is
time.
really what I
always.
need the luck for. Yes.
Yeah,
Thank you.
yeah, you do. They're a joy. They never grow old. They stay puppies.
Yeah. He's getting bigger, and yet in my mind, he's still a puppy. Yes.
Yeah. My 7-year-old's still a puppy. Just ask the age when they arrive at the house. Jennifer Pullman, representing the Center for Crime Victim Services.
Good morning, committee. For the record, my name is Jennifer Pullman, and I am the Executive Director for the Vermont Center for Crime Victim Services. And on behalf of the center, we certainly are grateful for the opportunity to weigh in on H 534 relative to sealing and expungement. The center does support this compromise bill. We see it as achieving the goals that were identified in terms of expanding the crimes that are eligible and moving towards a one-track system with narrowed access. We, from our vantage point, would prefer that the access remain as it was in terms of criminal justice agency having access, but we understand again that this is a compromise. And for us, the exemption of the crimes that are not included, not considered eligible, is really a critical piece that makes it possible for us to again support the bill. We think that the crimes that have been identified and exempted are obviously ones that just a brief review have more personal impact on victims, and so that piece is really important for us. And again, we do recognize this as a bill that everybody is happy with a good portion of it, and that there are issues, but the center does support the bill as written.
Well, thank you. I do want to point out that we're not a part of that compromise here in the Senate Judiciary Committee. So we're starting back from square one, but using the House passed bill as a guide. But I don't think we're a part of the compromise. So I think we'd be willing to put our own stamp on it.
Thank you for that consideration. And I do agree that it would be most helpful to have David Diamora and to guide that discussion. And so I appreciate that he'll be joining the committee next week, as I understand it.
Well, we hope so. He's on vacation this week, and so we didn't want to disturb him any further. But we'll see when he's available, either next week or the following week.
Thank you. And for us, the current exemptions that are in this bill would be important that they remain, especially with respect to DOC access in terms of being able to do their risk assessments. But I anticipate you'll hear from DOC on that as well. If it would be helpful, I'd like to just turn to the specific provisions in this bill that the center was a part of recommending.
Yep.
Thank you. With respect to this issue, and Senator Nick had raised a great question yesterday relative to how do agencies and entities know that a record's been sealed. So on page 19, you'll see in subsection A towards the bottom, we had requested that the restitution unit receive notice of a record being sealed. Currently, we do not receive notice at all. We do generally get them for expungements, but we don't get them for sealing of records. And we're not notified either ahead of time in terms of whether a petition's been filed. So we're really appreciative of the fact that this bill and current law expects that restitution is paid before granting of either a petition for expungement or sealing. But in practice, we don't, especially with sealing, we don't learn anything until after the fact. This has happened again with expungements, or we've had to petition the court to reopen a case where that's happened. So for us, from a liability perspective especially, it's really important that we know how a record is to be handled and treated. So we had specifically asked for that and are happy that that provision is in there. Then you'll see on page 22, there were two specific provisions that we had requested be included, and perhaps the language is familiar to you from our discussions relative to H224, the juvenile bill. You'll see subsection 6. We had requested that the Victims' Compensation Program be provided with a redacted copy of the affidavit for purposes of verifying the victim's expenses. It's not common, but it is possible, and it has happened, where a victim has sought to apply for compensation after a record has been sealed, especially with respect to mental health issues and expenses. There are victims' healing and process of that incident doesn't always occur within the time frame that a record is out and eligible for review. And at different times of a victim's life, issues can come up that may or may not have been recognized during the time when a record was open. We did speak with Judge Zone at Chairwoman Grad's request to make sure this was not going to be a burden on the court and was doable. And Judge Zone confirmed after a consultation with his people that this was absolutely possible. And so for us, this is just a really important piece that could make a significant difference for victims, and again, does not entitle us to any information whatsoever around the offender's identity. And again, that language, as you may recall, was consensus language by all the parties. And as you've heard, there is no disagreement with that language thus far from the witnesses on this bill. If you go down to subsection 7, you'll see another familiar piece with respect to the restitution unit and its ability to enforce a restitution judgment order, which per Vermont statute is recognized as a civil order. And as the committee recalls, there are no...
Excuse me, I got to step away for just a few seconds.
And as your committee recalls, there are no criminal consequences to non-payment of restitution. And so again, we're just mirroring the language that you've already seen, making it clear that pursuant to current statute and also pursuant to a court decision, that the sealing of a record is not a bar to the restitution order being able to be enforced. And then finally, with respect to the penalty unauthorized disclosure issue on page 24, I'll defer largely to the network on this piece and to Ms. Barquist, but the intention from our perspective was to make sure that victims are not unknowingly brought into to a piece where they could be civilly penalized for inadvertent disclosure. I mean, our agency, as I alluded to, doesn't even know when a record's been sealed, and I don't think it's reasonable for us to expect that a victim would know that, and we wouldn't want to also penalize a victim being able to share their own experience. We've also been through this issue relatively recently on H224. And I think we all were in agreement in terms of when we were in the House that that's not the kind of conduct that we want to penalize. It's more the use of this information by someone in their official course of duties. And I did hear Senator Bruce yesterday raise the issue of access of that information. And certainly that would be a piece that as long as the qualification remains that it's relative to somebody in the course of their official duties who knowingly does that, that would absolutely be something that we would support.
Thank you. I'm in agreement with you about, my comments weren't ever directed at victims or an attempt to penalize victims. The one place I might differ slightly is a law enforcement officer accessing in pursuit of official duties would be one negative scenario I could imagine. Another might be such a person accessing not in pursuance of their duties. So you have a law enforcement officer who isn't on duty or on a case, but let's say for personal reasons accesses this information. I wouldn't want that not to be covered, but I think it shouldn't be too hard to distinguish victims discussing their own lived experience from this field of other activity.
Thank you. And I certainly didn't understand your comments in any way to be of that nature. We wanted to just ensure that you understood that we supported the overall intent to think about unauthorized personal access by individuals, and that's a concept that we support.
Yep. I interrupted you. Do you have more, Ms. Pullman?
At this time, I do not. I will be interested to hear what David Diamora has to say, and if there are changes or proposals that will change the access language. But currently, again, we support the bill as drafted, but are eager to watch this piece as it goes through your committee.
Okay. I see Senator Sears is back, but he is muted. So are there any questions for Ms. Pullman? Okay, thank you.
Thank you.
Why don't we move to the network and Jessica Barquist? Good morning, Jessica.
Good morning. Thank you all for having me. For the record, Jessica Barquist from the Vermont Network Against Domestic and Sexual Violence. And thank you for the opportunity to testify today on H534. The Vermont Network is broadly supportive of your efforts to expand record clearing eligibility in the recent years. And we recognize the barriers that criminal records pose for many individuals in Vermont, including our justice-involved victims of domestic and sexual violence. Sealed records can provide a path to more stable housing, employment, and financial opportunities, which not only benefit these individuals, but can strengthen our communities as a whole. And so the network also recognizes the long-term and sometimes lifetime impact of crime on victims. Overall, we support H534. We are especially appreciative of the careful carve-outs of crimes related to domestic and sexual violence. And I just want to take a moment to highlight two other sections that are of particular importance to us, both of which have already been discussed today. But the first is victim restitution and compensation. So we support the language that's been added to this bill to ensure access to sealing related information for the restitution unit and the victims' compensation programs. Although current law requires that restitution be satisfied prior to a petition being granted, unfortunately, we know that there are cases where restitution has not been satisfied prior to those records being sealed. So this direct notification made to the restitution unit when a petition is filed is really essential and will enable the restitution unit to ensure that those orders have been satisfied prior to sealing. And likewise, it is equally important that the victims' compensation program remain available to victims after those records are sealed. Allowing the compensation program to have a redacted copy of an affidavit to qualify a victim for compensation is an important safeguard of victims' rights. For some victims, it can take years for them to realize those impacts of crimes and potentially after those records have already been sealed. So this will allow victims to still seek that needed compensation to assist with their healing after a record has been sealed. And then the other section I want to talk about is the unauthorized disclosure piece that Ms. Pullman just talked to you all about. In its original form, the original language in the House Judiciary Committee, we highlighted some concerns. This is now section 6 on top of page 24. And our concern, as it was originally written, was that the language was too broad and could potentially create a civil liability for victims who shared that information about their experience. So we proposed the language that you see in the current draft in section 6. And really the intent there was to clarify that the liability regarding the unauthorized disclosure sat with the actors in the justice system. So while we support the language that's currently drafted, we would have no objections to an additional language or clarification that it's not just the disclosure, but it's also that unauthorized access or unauthorized use. I think that makes good sense, and we would support that as well. And that's all I have, but super happy to take any questions.
Are there questions for Jessica?
Not for me.
Jessica, thank you for joining us this morning. And can we talk a little bit about this unauthorized disclosure? Because we did this, I think, in the juvenile bill that we just passed. We had the same discussion. So it is not. So you're comfortable with the way it's written with possibly Senator Baruch's amendment?
Yes, we would be agreeable to that.
Thank you. Other questions for Jessica? Hey, thanks so much. Commissioner Sherling from the Department of Public Safety. Seems like we're meeting daily, Commissioner, if you're on appropriations.
Good morning.
Good morning, and thanks for joining us.
Thanks for having me. Again, for the record, Mike Sherlin, Commissioner of Public Safety. Excuse me. I'm gonna try to contain my testimony to relatively narrow window, but by way of backstory, in part, I believe this bill is an extension of testimony we provided last year on an expungement bill, where I suggested that a unified system, simplifying the system of sealing and expungement, would be a laudable goal, and that we support expanding both the universe of things that could be sealed and accelerating the timelines with which seals could be placed in the interest of all the things that you have heard from a variety of folks that have testified on this, not only now, but over the years, to allow people who are justice involved, but not perpetually justice involved, to get past their prior transgressions. And we stand by that, that position. Part of what I testified to last year and have testified on that in the House on this bill is that, in our view, the key is to balance that overall policy goal with the nuances of executing that policy to ensure the requisite amount of requisite intersection with public safety and the ability for other components of various systems, whether they're the courts to unseal records under certain circumstances, or for even a prior defendant, someone whose record is being sealed, to access that record going forward. Because there are a host of reasons why that might be important, including to refute an inaccurate account of something that has happened because a fragment of it or a vestige of it remains in the public view as a result of media coverage or someone's recollection or something of that nature. So with that as the backdrop, I'm going to speak specifically to criminal justice records, as have been referenced, I guess, yesterday and also a little bit prior to my testimony beginning today. There is an existing exemption, as Senator Sears has indicated, for criminal justice purposes, including the maintenance of law enforcement databases, that has been in existence for decades relative to records that are sealed under existing statutes for deferred sentences and for juveniles in particular. I am not aware of any problems that have occurred as an extension of the way in which those records get sealed today. In other words, juvenile records are not inappropriately brought up or brought into debates or instances where there are new contacts with someone as an adult, despite the fact that they exist in law enforcement databases. It's important to note, I guess I should back up one step. From an operational perspective, there are multiple criminal justice uses of this data, but relative to policing specifically, there are two different data sets that exist. One where Director Wallen would be better suited to give you the nuances of the impacts on criminal histories that are housed by the Vermont Crime Information Center and similar centers around the country. And two, law enforcement databases, which are sort of the day-to-day records of events and contacts, the vast majority of which, it should be noted, are not criminal contacts with people. So somewhere between 80 and 90% of the data that are in those systems are not things that rise to the level of crimes that are charged in the criminal justice system. So as we look at sealing, there is an impact on the records in the Vermont Crime Information System and the official criminal histories that the state maintains. And there are potential impacts to the day-to-day operations and access to data sets in law enforcement databases. So with that as the backdrop, one of the things I testified to last year, and I have reiterated this year, is that while we stand by the the policy position that both expanding and accelerating the sealing of records, if it's done in a mindful way, is a laudable public policy goal. Deleting records of government action is not good policy. And that is in part what's contemplated in the bill as drafted. As drafted, there would be a substantive change in the effect of sealing on criminal justice records, and would, for all intents and purposes, it would delete those records. And that is problematic for a host of reasons. There are, and these are in no particular order, we rely, and public safety in general, not just law enforcement, but other emergency responders that are dispatched by our emergency communication centers, rely on details from prior responses to enable the safest possible response to a scene. So embedded in those reports is not only the potential accusation against a person of a crime, which we are suggesting should be sealed from public view pursuant to the structures that you're debating here relative to sealing, but should not be eliminated from view for emergency responders, because they not only contain the accusation of the crime, but they have behavioral information, they have environmental information, they have information about everything from animals to things that might cause a person to have a triggering event. That I've seen flags in records where blue lights may cause a seizure in a person, and you want to know that it's important to shut your blue lights off before you arrive at a scene. It can be that nuanced. It could be more general, that someone's ongoing history of contact with law enforcement, or contact with the fire service, or contact with mental health responders from a designated agency is a trigger for them. That when one of those entities approaches a person first, they react poorly. We want to be able to maintain that kind of information so that it informs the best possible response, which is actually a goal of the use of force statute that the legislature passed last year, wherein a component of that requires responders to take into account the totality of circumstance and various information that's known about a person's, I'm forgetting the exact language, but issues that a person,
I think we
may. Yeah.
I think we're good.
Thanks. Additionally, removing those records will impact data reporting, because once you delete them from the database, you won't be able to report out on things, including use of force, which is a key topic under debate in a variety of different bills this year. But just generally knowing trending around crime and other statistical things that are important that are taken from those databases is something that would be impacted by removing those records from the databases themselves. Now, some may argue that the indexing that is proposed will assist in counting that information, but it will fall significantly short, because the indexing will only take into account a small cross-section of information that's contained in the records, and there's excuse me, an enormous amount of additional information that is statistical in nature that is important going forward, both for year over year, but also for long-term trending on the impact of opiates, of mental health, of various types of crime. All those kinds of flags and information are in these data sets. So the more we remove from those data sets, the more inaccurate our picture of our underlying challenges, where we need to make investments in public safety and health. It impacts all of that. Information also could be helpful to inform future civil litigation. So in some cases, you may want a record of a government employee's pattern of conduct to help inform litigation against that employee. I use that as an example because it's top of mind here in the over the last couple of months. But you may also, and I would submit more often, actually need to look at a government employee's course of conduct and use that in a defensive posture against litigation that occurs. So being blind to someone's work history one way or another because you've eradicated these records from our field of view has a predictable consequence going forward. Other examples include the impact on more complex and long-term investigations. It is not uncommon for historical records to be used as corroborative evidence in major cases. So just knowing that a person was in a particular place at a particular time, or corroborating that a witness or victim says, listen, I reported this thing on December 1st of 1993. I remember it was December 1st because it was my birthday. And that was the first time I met this person who later victimized me 18 years later. Those little fragments of information can actually help to weave together a major case, even though the information could be decades old. That's the way that those kinds of investigations often unfold. So I bring that up to say that there are nuanced, tiny fragments of information that are essential, even over, in some cases, decades, that help to achieve good public safety outcomes, good legal outcomes, and good outcomes that support the victims of crime, again, especially in things that are complex investigations where you're trying to weave together a variety of small fragments of information to make a case. I'll pause there. There are a variety of different examples that I can get into, but it may make more sense to respond to committee's questions rather than continue down a variety of potential paths here. I'll just say that eliminating access to these records will have data reporting and public safety consequences that we can anticipate and some that we cannot anticipate. I've outlined a few this morning. I mentioned that they can even disadvantage historical defendants because there are times when a prior defendant may need access to their records, and we would suggest that you retain a mechanism for folks whose records have been sealed to access their own record in the future, because there are a variety of instances where that could be helpful. And just a final note, again, as Senator Searson indicated, there is a multi-decade track record of law enforcement keeping these records confidential and not using them for inappropriate or nefarious reasons. And that is the most important thing that gives me confidence that not altering this system is safe and achieves the goals, the overarching policy goals that we're trying to achieve here. So I'll stop there.
Let me ask, I do want to ask questions to particularly understand because, frankly, the juvenile system we've had so much experience with it over the years, but I'm not actually clear on what access you have. I know I still have to keep information about kids that I dealt with 40 years ago. It's supposed to stay confidential. And I can't divulge that. However, sometimes it is immaterial. But so a kid who is say 60, he's no longer a kid. I take one of my first residents. I've maintained contact with him for the last 50 years. He just turned 65. Now lives in Massachusetts. Would someone have information on his sealed juvenile record, and of what possible value could that be?
At this stage, its value is likely non-existent. Does that record exist somewhere in on paper? The old card file systems that existed back when he was a juvenile? I don't know the answer to that. It's possible. There are certainly logs in places like Burlington that are even handwritten that date back to the 1800s with people's names in them. They have no operational value at this point, but those historical records do exist.
But you could still, because he was a juvenile 50 years ago, you could now access his record under the current sealing law for juveniles, correct?
If it were maintained for that period of time.
Yeah,
yes,
obviously we're dealing with something that's so old that it's probably was lost in the flood in Irene. But I'm just trying to understand how you would use that information. And I have not heard of problems with kids who were in my custody way back when ever had a problem with their information being disclosed.
I've not heard that either, Senator, and it's probably the best example you can give, which is those juvenile records that once someone becomes an adult, they do not transfer over because A, they're juvenile, and B, they're sealed. And that I would envision, and we've suggested the same thing here, that once you seal a record for an adult, it does not transfer. It can't be used in an affidavit, for example, supporting a charge, a new charge 10 years later by standing on an old charge saying, well, this person was charged 10 years ago because it's been sealed. Same effect is what we're suggesting should happen.
So if we track the juvenile system, and obviously we need a lot more discussion about that, but if we were to track the juvenile sealing system for this sealing, you would be okay with that?
Yes.
May I ask a question, Senator Sears?
Sure.
Thank you, Commissioner. I appreciate a couple of the, I appreciate your testimony, but a couple of the things, like when you were talking about the information that's contained in records, that just the example of the blue light, and I understand that, but we're talking here about really old records that they don't even get sealed until after I think the minimum time for misdemeanor is like 6 years or something, and for felony it's 10, 15 years it would be. So you do have access already to kind of those more immediate issues around people's response and what triggers them. And the other thing I appreciate, and I'm not sure how to do this, is around the kind of really complex long-term investigations that something may show up. So I don't know how you get around that, but I do have I don't know, I have some concerns because you have access, right? Under this, even you would have access to records until they're sealed, and though they aren't sealed for a long time. So those issues around people's response and what triggers them and stuff, you would have access to for the most part, because that might change after 15 years. So it's the long-term investigations that I guess I have a concern with, and how we do that.
Well, I appreciate that. Well, if I may respond, the sealed record may be the only contact that law enforcement has with a particular individual. So the fragments of response information that are embedded there may be the only pieces that help to inform a future response to a particular location or person. So the age, the fact that there's, well, I also wouldn't say that a record that's 3 or 5 or 7 years old is particularly old. That's for criminal justice reasons, its predictive value of future criminal behavior, it is old. It's the rest of the information that goes to whether it's data reporting and statistical analysis or information around environmental hazards, for example, is not necessarily dated.
Okay. Yeah, and I appreciate that, and I mean, we just dealt with this yesterday around records of birth certificates and historical information and research and how we determine where we're going to put our resources. So I appreciate that. Thank you. And I'm not going to, I guess it isn't your place to weigh in on the DOC and the courts, but I'll leave that to them, to that section, to allow them to look.
Well, I think it's no secret where I'm headed here, and that is looking at what we already know about sealing of records, which we've been doing for decades on juvenile records. And why would we, I'd love to hear from opponents' idea of using the system that we have in place for juveniles in terms of sealing records of adults. So I'm happy to listen to why that's a bad idea. But
Thank you.
Senator Baruth, you're going to tell me why it's a bad idea.
I am not going to tell you why it's a bad idea. But I will say that I don't think it's necessarily apples to apples. And my thinking is that I think there's a greater temptation if we're talking about a population of adult offenders who have had adult convictions expunged or sealed. I think there's a much greater temptation to go into those records than there is to go into juvenile records. So the fact that we haven't had a great number of disclosures unauthorized from juvenile records, I don't think is necessarily predictive of what could happen if, as Commissioner Sherling is arguing, we gave law enforcement continued access to those adult records. So I just wanted to say, oh, go ahead.
No, it's extremely limited access, though.
Yes.
If I may, Senator, the same scenario does play out with adult records as well. We have sealed adult records in our databases, and I am unaware of any inappropriate use or unauthorized disclosure of those records either.
But aren't we talking about a very significant expansion of the number of records that would be sealed?
We are, because we've suggested that that's the way to go.
Right.
In part because we've suggested that.
So my point is that as we allow more qualifying offenses, as we expand the number of sealed records, it's going to be increasingly tempting to law enforcement to want to go into that larger and larger database. Commissioner Sherling, your testimony was predicated on the idea that there were tantalizing bits of information that could be of use to law enforcement. All I'm saying is that if we prohibit that use, that's because we agree with you that those might be tempting to law enforcement to want to dip into.
Yeah, it strikes me that I need to be more clear about what I'm describing sealing should be. What I'm describing is that the record, so to use Senator Sears' juvenile example and to extend that also to other sealed records that are in our databases now of adults, we could pull fragments of information to help inform a response, and we could report on statistical information that's to count those records toward, counting the number of things in which blue shoes were worn. I'm just making that up. We would probably not need to report that. But if someone were to ask and we did a search, it would report, we'd be able to report on that statistic. What we do not do and cannot do is disclose that a particular person was even involved in the event, or B, accused of a crime as a result of the event if it was under seal. It's also important to know, as I indicated, 80 to 90% of the records in our databases are not records where crimes have been charged, but there is a fairly substantive cross-section in which people have been accused of crimes. Those are, under existing regulations and public Freedom of Information Act law, not subject to public disclosure. You cannot call us and say, I'd like to know if Senator Dick Sears was accused of X, Y, or Z. And I should be really clear, we have no records to indicate there's, I'm just making this up, just in case someone wants to try to twist that into
Well, it wouldn't
something.
surprise me, Commissioner.
Well, you'd know about it because we would have interviewed you most likely. But
Seen it on Facebook, actually.
the net effect that I'm suggesting is the same as any other accusation of a crime that never made it to a courtroom. We hold those things confidentially as part of our professional responsibility day in and day out. There are literally millions of those records, and they are not publicly disclosed. And on the rare occasion where someone even, I'm not aware of any where they've been publicly disclosed. I'm aware of a couple in my 30-year career where they've been inappropriately accessed, and employees have been significantly disciplined just for looking at records that they do not have a professional reason to look at.
But Commissioner, if I could just repoint us to where we started here. We were in the process and the business of expunging. Then the suggestion was made to move to a single track that was more like sealing. In so doing, we were going to be giving up the reassurance that people who had had their crime expunged, the reassurance that there literally was going to be no record. And so in our earliest discussions in Joint Justice Oversight, for instance, I tried to make clear that if we're going to give up that kind of reassurance to people, that the record is actually gone, it's been wiped and destroyed, and we're going to go to a system where the records still exist, but they're going to be sealed, I personally can't vote for a bill that creates the sort of access that you're talking about. So to take an example that you gave earlier, someone responding to a call goes back into the records to find out that someone is sensitive to the flashing lights of a police car. And then they can use that to police in a more effective way. But if you think about that, that's somebody who on the fly is going to access these records, go back through, sift through that information. The troubling thing there is that it will continue to inform law enforcement's view of them when it was supposed to have been expunged.
I understand your concern, not necessarily, because the types of alerts I'm talking about, while they exist in that record, are flagged in an automated way. There's no sifting that has to happen. It would just show up and say, you know, if you interact with this person, please try to avoid using blue lights in close proximity. But if you delete the record, that flag cannot appear.
Well, and there would be trade-offs in the same way that when we were in the business of destroying the record, right, where we were erasing actual documents, which we had lots of testimony about how expensive and time-consuming it was to physically destroy the records. But when that happened, they were gone and nobody could use them. And there were trade-offs, but the decision had been made by the legislature to err on the side of clearing the record of the defendant. So that's all we're talking about here. What I see you doing is going back and relitigating that discussion on behalf of public safety.
I would actually make the reverse argument, Senator. I understand what you're saying. What I'm saying is the inverse, but go back to the beginning of what we suggested, going to a universal system of sealing rather than expungements based on two things. A, you want to be able to seal more records faster, laudable public policy goal, but without the collateral damage that currently occurs by eradicating the record of government action in the expungement system. That's not good public policy in my view. Deleting the actions of a police officer in particular, given all the conversations we're in right now, is not a good idea. And that's what we're talking about doing. So what we're suggesting is you seal the record, you do not eradicate the record. And the effect of sealing is it cannot be publicly disclosed, but the nuanced contents of what's in there to help inform better response, to be used to corroborate evidence of other things in the future involving people that may not even be the accused, are all valid public policy uses of the information.
I think I'm guilty here of jumping ahead of something that we should have a long discussion about, and that is actually what is the impact on the current system of our sealing of juvenile records, so we can better understand. I don't believe the law enforcement officer has necessary access to all the details of a juvenile record that's been sealed. I think there's some access, but I think there's a long process to get the actual record. We need to talk more about that.
State archives.
Can I, I'm sorry.
I just weigh in here. So, Mike, where do your records go when they're closed and you're done with them? To the state archives?
No, the historic paper files, yes. In the 21st century, they are electronic databases. So it's called a computer-aided dispatch and records management system, where there is a digital record of the event that includes the initial response information, people, vehicles, evidence, documents, digital evidence, etc.
And how long is it kept in that format? How long is it kept? In other words, are there any markers on those records that say, confidential or anything like that on some of those records?
There are. That's a great question. The sealed records that Senator Sears has been talking about, and I've been expanding on, are marked as sealed. And so I'll try to explain. If you were to look at records that are records of arrests and criminal conduct on one side, and other records on the other side, the other records are the names contained there are largely private, with a few exceptions that are outlined in the public records law that the legislature has passed. The records of criminal conduct, the default position is they're largely public, with exceptions being for things that are headed to a family court. And I'm oversimplifying here. There may be a couple of other nuances, but things headed to family court, historically juvenile records, and then anything that is placed under seal. That then makes them treated like the other things that are in those databases that are largely, the name records at least, are largely not accessible to the public. But if you were to call or you to file a FOIA request and say, I saw a heavy police response with ambulances and fire trucks to 1 Main Street yesterday at noon, you do have access to the record of government action. We would redact the name information if it wasn't a crime or it wasn't something involving the operation of a vehicle where arguably your name as the operator of a vehicle or person involved in an accident is public because you've chosen to exercise a privilege to drive that vehicle. I'm oversimplifying this a bit. Those are the general parameters under which things are forward-facing in public and not. But in almost universally, with the exception of juvenile cases, the record of government action is publicly available with the names redacted. And that's part of what I'm suggesting here, is that record of government action is important to be public for a longer period of time.
Thank you.
Are there other questions for the commissioner? And I would like to have you back at some point, Commissioner, to further expand on where we do go when we're working on this. And I do appreciate, I also would like to meet with you about the budget at some point, and I don't know when I'm going to see you in person again, but maybe next Thursday, a week from this Thursday would be good for me if you have some time to talk about budget and particularly dispatch and understanding what's going on there.
Making a note of that to reach out to you.
Yeah,
now,
if you
so-
let me know what's good, either noon time or like 4 o'clock can work.
Got it.
Great. Are there
My
other
apologies
questions?
for stepping out for a moment. I got an emergency phone call.
Oh, well, hopefully things are okay.
Yeah, everything's fine.
Jay, what's your schedule like? If we were gonna take a break at 10:15, do you wanna go now and take a break after your testimony, or do you wanna wait? It's up to you.
My schedule is fine, so it's really what is more
Would the
convenient. for
committee
the-
like to take a break for 15 minutes? A
Love to.
quarter of 11?